Introduction to Business, Chapter 5, The Legal Environment. This chapter is going to be about all the laws that apply to businesses. We are going to be looking primarily or almost exclusively to the United States laws. Obviously, if you're involved in international business, different rules will apply in other places, but we're going to be talking about how the United States establishes the laws that we have to abide by. The meaning and purpose of law, it's basically a set of rules that you have to do or you could face consequences that would be enforced by the government. When we say law, we're talking about all the rules governing society in general. It's usually put in place by some type of political authority. In our case, it's either the state or federal government. We have a dual system of law and politics in the United States. Each state has their own governor, court system, and legislature that creates and enforces the law. But the federal government also has it too. Congress consists of the House and the Senate. They're the ones who put bills together, and then eventually they get passed by each body of Congress. It goes to the president. If the president signs it, it goes into law. And then the court systems are the ones that actually enforce the law. The purpose of law is to maintain order, create standards, resolve conflicts, and protect individual rights and liberties. In the United States, we have what is known as an adversarial system of law. We have a plaintiff, who is the party who brings a complaint, and a defendant, who is the party who answers to a complaint. The court system does not mediate. If you are going to court, you are either going to win or you are going to lose. Many businesses do try to do things like mediation to try and avoid the cost and the consequences of going to the court system. Mediation is simply when you come to an agreement to resolve a dispute where you can compromise. Because we have an adversarial system of law, when you go to court for litigation or for a lawsuit, there's only going to be one winner. We are a nation of laws. They should apply to everyone equally, and everyone has to be accountable for compliance. Promulgated means that they are published, so they are publicly promulgated during the process of developing them, finalizing them, and then publishing them for everyone to be aware of. They should be equally enforced regardless of who it is that is subject to the law. They are independently adjudicated, meaning that you don't have a party with an interest overseeing the results. So hopefully you would go to a court, you would have a judge that is uninvolved with the matter at hand so that they can make unbiased decisions. There are four main sources of law. In the United States, we have the Constitution. Constitution is essentially a list of all of the things that the government does. The federal government has the Constitution, and it basically is broken into several different parts, but the three main core ones are the section that establishes the Congress, which consists of the House and the Senate, the executive, which is the president, and the court system, which is primarily the Supreme Court. Congress has passed laws to create other inferior courts. The Supreme Court basically has the ability to make rules that all the other courts have to follow. There are 51 constitutions in the United States. Massachusetts has its own constitution, but the federal government is known as the supreme law of the land. There's something called the Supremacy Clause in Article 1, Section 8 of the Constitution. We can have another constitution, but it cannot conflict with the federal constitution. We can provide more rights, but we cannot provide fewer rights. So, for example, a federal law concerning minimum wage establishes the minimum wage at $7.25. In Massachusetts, it's at least $15, and it's probably going to go up again. It's been going up over the last couple of years, according to a law that was passed here. It's okay to have minimum wage that's higher than the federal mandate, but it can't be lower. The First Amendment gives you freedom of speech. Massachusetts can have freedom of speech as well, but we can't have any infringements on the national rule, because everyone who lives in the United States, you are a citizen of the state in which you reside, but you are also a citizen of the United States. And when it comes to any kind of a conflict regarding how the law should be applied, the federal government, where they make a rule about something, preempts any other state rules and laws. And it is basically the supreme law of the land, so you have to abide by it. The Constitution also reserves rights, things like freedom of speech, religion, press, Fourth Amendment right to be safe from searches and seizures, Fifth Amendment right not to be prosecuted twice for the same offense, and the right to remain silent. There's a lot of other things in the Constitution, and the federal Constitution is something known as the Commerce Clause, which gives the government quite a bit of leeway in regulating businesses, particularly businesses that operate in interstate commerce. That means if someone in Massachusetts is doing business with someone in New York, the federal government can regulate that. Anything that happens intrastate, meaning within the state of Massachusetts, our government should be regulating that. In addition to constitutions, we have what is known as the common law. The United States inherited its legal system from the British because we were colonized by Britain, and our rules go back about 1,000 years through case law from England. Still today, we are bound essentially by the same rules that were developed in England over the last several hundred years. Common law is known as judge-made law. So if you go to court, you would get a decision that would be made by the judge, and the judge would establish some type of rules that you would follow. That is known as precedent, based on the word precede. So if you go to court after the case has already been decided, they would look at the precedent, the case that was decided before, and they should decide your case the same way. Through multiple cases coming in multiple different subjects, judges over time had developed laws through their decisions. They involve property, contracts, torts, criminal law. Most of the basic laws that we know today in the United States came from case law that was decided by judges over a long period of time. We also have statutes, and this is what most people think of when they get an idea about what a law is. This is when either the Massachusetts legislature or Congress passes a bill and it gets signed by either the governor in Massachusetts or the president in the federal government. And then it goes into a book and it's a law that everybody can read and you have to be bound by it. The common law and statutes can complement each other. Sometimes, for example, in Massachusetts, the definition of murder is a common law decision that was made, a few hundred years ago in England. We don't have a statute that necessarily defines murder, but it does define the punishment for it. So they can kind of complement each other. Statutes are also sometimes written to create federal or state agencies to handle certain courses of business. So, for example, the Internal Revenue Service, the IRS, the people who collect taxes at the federal level, they exist because Congress passed a statute that said that this administrative agency would exist. And that administrative agency has the authority to issue regulations, which is basically a far more detailed level of what the statute is giving them the authority to do. So you have to pay taxes. They'll also pass the tax code as a regulation, which will explain who has to pay what the rates are, how you file, what the punishments are, etc. That may not be specified in a statute. All the details would be given in a regulation. I've heard people say, oh, I don't have to worry about breaking a rule that's in a regulation because it's not a statute or it's not a law. That's not correct. A regulation is a law. It is enforced by a government agency or an administrative agency, but it has the same effect of law because those regulations were passed under the authority granted by the statute, which came from Congress, which came from the Constitution. So it may be a lower level law, but it is still a law and you can still get in trouble for it if you fail to comply. As I said, the common law is based on the concept of precedent, so judges would decide prior rulings and try to figure out what's going on and come up with a fair decision. So 500 years ago, somebody in England had a contract with somebody, they made an agreement, and the agreement was broken. So they go to the judge and they say, here's what happened, what do you think? And the judge would look at those facts and then make a decision for one party or the other. And that decision now establishes what the precedent is. So another case that comes with similar facts should come up with the same decision. And over time, the law gets more and more refined. Typically, precedent is established by higher level courts. Mostly in the federal government and in the state government, we have 3 levels of courts. Essentially an entry level where you would go in and start a lawsuit. You would have an appellate court, which would review the decision of a judge. They do not necessarily review jury decisions of fact. They look at decisions of law. So if a judge said that certain information should be admitted into court and he did so incorrectly, that is an appealable issue. So you go to a higher level court, and then they could tell the judge to fix it or they could approve it and sustain what was going on. If you don't like the appellate court decision, you could go to the Supreme Court of the United States if you're lucky enough to have them hear your case. They're not required to hear all of the cases. In Massachusetts, we have a similar structure. We have entry-level courts, the Massachusetts Courts of Appeal, and we have the Supreme Judicial Court. The model for both the state and federal governments are very similar. As noted, statutory laws are passed by Congress or in Massachusetts by the state legislature. The constitutions give Congress the power to pass laws, And when Congress does that, those laws are usually put into play. They may be enforced by a government agency as is necessary. Most of the time, when Congress submits a bill, they review it. A lot of them are just dead on arrival. They never get voted on. The current Congress has been particularly bad at getting bills passed. I think the slide says it's about 7% of bills become law. I think it's closer to 2 or 3% right now. So when somebody says, hey, there ought to be a law about that, you go to your representative, they file a bill, and if they can get enough people to vote on it, it'll pass. But the vast majority of them do not. If the Senate agrees and then the House agrees that the bill is good, it gets passed and sent over to the president. If the president likes it, the president can sign the bill, it becomes a law. If the president doesn't like it, it gets vetoed, and that is basically trying to kill the law. If at least two-thirds in both the House and the Senate vote in favor of the law, it doesn't matter what the president says. They will put it into law anyway. It's called an overriding of the veto. An interesting thing about the way the House and the Senate are comprised, the House is based on the number of representatives according to population. I think Massachusetts has about 7 million people. I believe we have 12 representatives, but we have 2 senators. California has 30 million people. They probably have 40 or 50 representatives. I haven't looked it up, but they have way more than Massachusetts because the House is based on population. But California also only has 2 senators. The reason that this was done in the Constitution is when the founding fathers put it together, you had people saying, well, representation should be based on population. The big states were very happy with that, but the small states didn't want to be pushed around and told what to do by the bigger states. So they wanted to have equal representation, but of course the big states didn't want that either, so they compromised. You have a Senate with 100 people from the 50 states, there's 2 from each state, and then you have 435 members of Congress, and each state has a different number based on their population. So a very small state will only have a couple. Bigger states could have dozens, but all of them have the same number of senators. So it's a way to balance the large and the small states together. A tort is known as a wrong. It's very similar to a crime. A crime is when you commit an action that harms another person, and the government, looking out for the interests of everybody, will prosecute you for that. And the outcome would be you could face a fine or you could face a restriction on your liberty. They could put you in jail. Criminal law and civil law are 2 different things. Criminal law is when the government is going after you. Civil law, meaning like civilization, from the Greek word for people, a civil court case is between a person and another person. The government is not involved except for the fact that the judge who works for the government is overseeing the case. So a tort is similar in many respects to a crime. You probably don't remember, most of you, but O.J. Simpson had been tried for murder and he was found not guilty. By the way, not guilty doesn't mean innocent. It just means that they couldn't meet their burden of proof that he had murdered someone. He was then sued by the families of the 2 victims in civil court. It's not called murder, it's called wrongful death. And he was found liable for that and had to pay damages, otherwise known as money. There's assault and battery at a criminal level, there's assault and battery at the tort level. There's also torts that apply to things that will be much more in line with what we're looking at here for business. So in common law jurisdictions, we inherited most of this from England, a violation of civil law that causes harm or injury to a person. And it could be physical harm or it could be financial harm. If you believe that you have been victimized by someone under tort law, you would have to go to court and file a lawsuit. And the damages, whenever they say damages, by and large, they're talking about money. You may get a court order telling somebody to do something, but most of the time when they say damages, they're referring to cash. I compared tort law to criminal law because many of the claims sound kind of similar. The thing that's different is when you go to court, because you could lose a lot of money in fines or you could actually lose your freedom, and in some cases, not in Massachusetts, but in some states and under federal law, you could lose your life. The burden of proof, what the government has to prove to convince people that you've committed a crime, is higher than it is in a civil lawsuit. In a criminal case, the jury has to decide that it is beyond a reasonable doubt that the person accused has done what they have been accused of. In tort law and civil court, though, it's not beyond a reasonable doubt. It's a preponderance of the evidence. That means that you're pretty sure. You have to be pretty sure that they did it, but you're not beyond a reasonable doubt. That's why O.J. Simpson was not convicted of murder, because they could not be convinced beyond a reasonable doubt, but they were pretty sure he did it. in the civil case, and they said that he was guilty of wrongful death. There are three types of torts. You have intentional torts, assault, battery, false imprisonment. An assault is making somebody fearful that you're going to injure them. A battery is actually a harmful or offensive contact. Negligence is unintentional, and it just means that you acted in an unreasonable manner that caused injury to others. Strict liability, it doesn't matter if you acted reasonably. Whatever you're doing could be considered so dangerous that you were going to be liable, even if you didn't intend to do it, and even if you were very careful about it. We'll get to that in a minute. So as we said, negligence involves a harm that comes from an unintentional action. The courts created through precedent this whole idea of what a reasonable person is. There's really no good definition for that. People just have to think about what is common sense, what would a reasonable person do in a particular situation. If you find that the defendant acted reasonably, then they're probably not going to be convicted or guilty of negligence. If they did not act reasonably, then you could say that they should be liable for whatever damages their behavior caused. There are 5 elements in a negligence case. When I was in law school, I actually remembered it as 4, but they kind of separated causation here. So, number 1, you have to have a duty of care. If I open my store to the public, I have to have a store that is safe. If you come in and there's water on the floor and there's electrical wires hanging and somebody could get electrocuted, that would not be considered reasonable. I also have a duty to provide a safe place for people to come in and visit. So if I don't have a duty, I can't be guilty of negligence. But if I do have a duty, I have to act reasonably. And a reasonable person would make sure that a place is safe before they invite customers to come in. Breach simply means break. It's a fancy way or an old-fashioned way of saying break. So if I had a duty of care, you have to establish that that exists, and then you also have to establish that I broke my duty of care. The next thing is causation, and I always considered it to be 1, but we're breaking it out to 2. Factual causation. Did I fail to meet my duty of care, and did that cause harm? That's the first step. So they call this but-for causation. But for this person's behavior, would this injury have happened? But for my breach of my duty of care, would the damages have occurred? If the answer is no, then there's no negligence. Proximate causation, and if you think of the word proximity, it means closeness. There has to be some relatively close connection to my action or my lack of action and the injuries that occurred. When I was in law school, we covered a case where somebody set forth a whole line of events. Someone was standing on a train platform and they were carrying fireworks. And they dropped the fireworks and they got run over by the train and they went off and somebody got startled and they fell and they broke their leg. Is that the factual causation? Yes. This person's carrying fireworks. They should have been careful. They weren't. They went off. But what about the proximate causation? It's almost like the mousetrap thing. You know, you start one thing and a whole row of dominoes start to fall, and then at the end, somebody gets injured. If the court believes that it's too far removed in the chain, then you may not be guilty of negligence, even though you acted essentially negligent. So you have to prove that there was factual causation, and you have to prove proximate causation, that there is at least some reasonably foreseeable result that could come from that. In the case that I gave you about the train, the court argued that that was not reasonably foreseeable. If you dropped fireworks, you would figure maybe someone would be injured directly by the fireworks. They'd get burned, they'd have their ears ringing, there could be some type of damage to their clothing. But having the train run over it and have other people move and bump into someone and knock them over, that was considered to be too far removed from the actual negligence that did occur, so damages were not allowed in that case. Damage is the proof of harm. So if I walk into a store, they have a duty of care to keep the store safe. They breach the duty of care because there's water on the floor or there's ice on the floor because it's snowing outside. And then I walk in and I slip and fall. You look at causation. Is that the factual cause? Yes. Is it reasonably foreseeable that someone would slip and fall? Yes. So it's both factual and proximate. And if I broke my leg and had to go to the hospital, I have damages. Damages can also include emotional and economic or reputational damages. We'll talk about this in a few more slides, but I could get compensated. I can get compensatory damages for what I lost. I had to pay the hospital. I may also be emotionally damaged from it. I could have missed work, so you have to pay the time that I'd missed work. And in some cases, there could be reputational damages. That's typically intentional torts, not usually negligence. For strict liability, it means that sometimes some products are inherently dangerous. So strict liability is a higher level of liability. It doesn't matter if you didn't intend to cause harm. If you're selling a product that is inherently dangerous, if I'm selling a type of product that has the potential to be quite dangerous, the manufacturer has to make sure that it's covered as well as possible so that if any harm comes from it, they may be liable for it anyway. So you don't have to worry about due care, breach, and proximate and factual causation. All you have to prove is that the product was used and that it caused damages. Product liability comes a lot. It's an area of tort law. You could have strict product liability, but you could also have product liability. So if you manufactured something and you made a mistake, you would apply the law of negligence. So if I manufactured something and it didn't do what it was supposed to do and it caused an injury, then I would be liable for it. However, if the nature of the product itself isn't kind of inherently dangerous, you don't have to even prove the duty of care and the factual causation and the breach. Interesting on the second bullet, we talk about you have to produce products that are reasonably safe for both their intended and anticipated uses. And if you ever buy a product and you'll see a warning label on it, you'll think, well, this is kind of stupid. If you buy a bottle of Tylenol and you take it out, it's got the little packet in there that absorbs moisture, and it says on the packet, do not eat. I would think hopefully a lot of people would know not to eat it, but the fact that they have to put that label on there means that somebody at once upon a time ate it and got sick. So you have a duty to warn people of the reasonable and anticipated uses of a product. They tell you not to use the hairdryer in the shower while the shower's going because you'll get electrocuted. You would hope that people would understand that, but it could be anticipated that they may do something stupid because people are people. So a lot of the labels that you see, that's because they're trying to avoid product liability. And by warning people, it's giving them some type of notice that if you're using this product, you have to use it the way it was instructed to be used and only for its purpose. You also, as a manufacturer, have to anticipate that people could use it in a way that they shouldn't and try to warn them not to do that as well. The types of common product liability claims that we see are design defects. Like I said, you've made a car. Remember that the Pinto video that we had, they designed the car with a gas tank right next to the bumper. There wasn't any way to protect it. The gas tank would leak, it would blow up. So that's a design defect. You could have a manufacturing defect where they made a gas tank, but there was a problem with the materials. Or sometimes you see recalls for food. There was a meat that was out there, and I think there were particles of metal or plastic or glass or something that ended up getting into it. That's a manufacturing defect. It's not a defective design, it's the failure of the manufacturing process or the quality control process to eliminate the defect from the manufacturer. And if somebody uses a defective product that was manufactured incorrectly and they are injured by it, there could be liability. I just talked about warnings on the previous slide. Failure to warn is a problem as well, because if I have a product, if I'm selling a saw, a power tool of some sort, and I don't tell people to unplug it before you stick your hand in there, if you don't tell people to shut off the lawnmower before they start cleaning the blade, people end up getting injured. So you have to make sure that there are adequate instructions for the reasonably anticipated use of potential danger so that people will not be injured. In strict liability cases, as we said, you don't necessarily need to prove that the conduct was unreasonable. This is not negligence, it's a separate category. If you make a defective product, you're only subject to liability from harm if it's normally engaged in the business of selling that type of product. This is related to the thing called privity. So if I buy a lawnmower and then I sell that lawnmower to another person and that person gets injured, I'm not liable because I'm not in the business of selling that type of product. If I buy a lawnmower from Home Depot and I get injured from it because it was defectively designed or defectively manufactured, then I have a claim. But if I sell my lawnmower to someone else on Craigslist and that person gets injured, I personally am not liable because I am not in the business of selling that type of product. I just had a one-off exchange with another person. It would be the manufacturer and potentially the person who sold the product. The Home Depot could be liable for it as well. The defendant, who's typically the manufacturer or the seller, so it could be Toro if they're making the lawnmower in Home Depot or Lowe's or somewhere that sold it. You're only liable if the product is defective, and that's either by design or by manufacturer. If the buyer did a substantial change to it, they modified it somehow and that resulted in the injury, or they were using it for something that was totally unanticipated and unreasonable, then that plaintiff would not be able to win on that complaint. The thing about strict liability, and I alluded to it a minute ago, you don't need to have that privity, the connection between the party buying and the party selling. If I buy a lawnmower from Home Depot and they are selling a product, they are liable just like the manufacturer who either had the bad design or the bad manufacturer. This concept of law is known as vicarious liability. It's also referred to as imputed liability. That means that a person or a company could be responsible for actions committed by others. So Home Depot is in the business of selling lawnmowers. If you buy a defective Toro lawnmower or a Craftsman lawnmower from Home Depot is liable as well as the manufacturer. So when you do the lawsuit, you would name both of them as defendants. They are vicariously liable, meaning Home Depot as the seller. If you're in business, you need to be aware that if you're selling products, you may be liable along with the people that manufactured it and sold it for you to resell to people at retail. Whether you go through an intentional tort, which we're not really covering here, the only intentional torts in business that really come up are things like interference with contractual relations or defamation. To defame someone is to lie about them and harm their reputation. So if I'm a company or if I'm a consultant, let's say I'm an attorney and I'm working on my own, and somebody out there is saying that I'm a thief, I don't do very well, it harms my reputation and it hurts my business. If that is a false statement that they made, I can sue them for that. But that's an intentional tort. Whether it's an intentional tort, negligence, or strict liability, the whole outcome here depends on if there's liability, you want to get compensated for your damages. So if it's cost me money, if I'm injured, I miss work, whatever it may be, I got to get damages from the people that I'm suing. And there's two basic types of damages, compensatory damages and punitive damages. Compensatory damages compensates. That's why they're called compensatory. And it's designed to place you in the position that you would have been had you not been injured. So you would look at things like how much money did I have to spend on medical? How much money did I lose because I couldn't go to work, etc. Punitive damages, like the word punitive, it's based on punishment. So if a company acts so outrageously negligent, not just regular run-of-the-mill negligence, but they just didn't care if people died, like that Pinto video that we saw, they were perfectly content to let people burn to death because they thought it would be cheaper than fixing their product. They had to pay punitive damages. So not only did they have to pay compensatory damages for the injuries that were suffered by someone who was burned, they were also punished and they had to pay millions of dollars on top of that. It's basically to set an example. They also call them exemplary damages. You make an example of the defendant. Intellectual property is another item that is protected under law. I mentioned it in class kind of briefly, but the idea here is that we're talking about something that's intangible. It's not a product, but it's something that's like an idea or a product that you had written. There are three ways that you can protect intellectual property, and that's through patents, trademarks, and copyrights. The idea for intellectual property is to protect someone's ideas and not let someone else steal them. So if I come up with a great idea for a new product and I had to invest millions of dollars for a new drug, if I patent that drug, I'm the only one that can sell it for a period of time. Eventually, the patent expires and then other people can do the same thing. And I think I gave an example before about Tylenol. Bristol Myers Squibb, I believe, is the company that made Tylenol. They had a patent on it. The only people that could sell acetaminophen, which is the active ingredient, was that company. Eventually, the patent wore off or ran out, and then other people could then market acetaminophen, usually as a non-aspirin pain reliever. You can buy a CVS pain reliever. It's basically Tylenol because the patent on that had expired. Same thing with Advil and ibuprofen. You can get a non-steroid pain reliever, which is ibuprofen, and you can get that, a generic version of it as well. The reason that we do this is because we want to encourage advancement. We want people to come up with new ideas, but nobody's going to come up with a new idea if another company could simply steal that idea and profit from it. We want to let people have the opportunity to make some money, but at the same time, we don't want to give them a monopoly. So over time, once you've recouped your money and you're in the marketplace and you have an advantage because you were the first person there, then other people can enter it and put out cheaper products as well. It's typically cheaper because they don't have to pay to invent the product in the first place. The idea is that that would create a good, active economy. You would have new inventions coming up. People would be protected for a period of time, and then other people could then implement it when the patent runs out, and you move on to the next big invention and get a patent on that. So the United States Patent and Trademark Office, the USTPO, they give a patent for about 20 years after you file the patent application. It gives an inventor the right to exclude others from making, using, or offering for sale or selling the invention for the period that the patent is active. You can get a patent for design, you can get a patent for utility, which is how to use the invention, and you can get a plant patent. Plant patents are not a very big part of it because it's very specific to agriculture, but if you have a genetically modified food, tomatoes that look bigger, that taste better than the average, and you've come up with a way of creating that particular plant, this food product typically, then you could get a patent on that as well. A copyright sounds exactly like what it is. It is the right to copy material. So if I write a book, I have the copyright. I am the only one that can actually copy it and sell it. If somebody else copies it and they sell it as their work, then I would have a complaint against them. I can file with the government a copyright, but most of the time when you create either music or a movie or some type of media or writing, it's automatically copyrighted. You can file a copyright as well in order to make sure that your work is protected. There's a lot of issues with international trade here because other countries sometimes make copies of movies. They stream movies without permission. If you ever watch sports on the weekend, they say, this is a product of the NFL and NBC Sports, and you can't show it to anybody else without permission of the NFL. That's because they have a copyright. It's their product. They're putting it out there, and they have the right to make money off of it. If you believe someone is violating your copyright, if you can locate them, which is not always the easiest thing to do, you can take them to court. But if you're dealing with international courts, you may have to get attorneys that are familiar with the laws of the jurisdiction that you're operating in to see if it's the same type of protection that you can get. Copyrights should be kind of like patents and either go for 7 or 10 or 20 years or whatever the current period may be, but they have been running a lot longer than they were originally intended. And as the slide says, you can kind of blame Disney for that because Mickey Mouse should have been in the public domain by now. It was supposed to expire, I think, in 1978. It was probably 50 years or 70 years. They've changed the rules. So if you invent something like a cartoon character, like Walt Disney did with Mickey Mouse, it's the life of the author plus another 70 years. I think Walt Disney died in 1966. Add 70 years to that. Eventually, Mickey Mouse will become part of the public domain. It will not be protected by copyright. And when that happens, you'll see Mickey Mouse everywhere, and it won't be Disney. It's the same idea behind patents. The intent is you create something, you get to keep it for a while, and then over time, it becomes anything that anybody can use. For music and movies, for example, if you have a band and they want to use that music in a movie, they have to pay the band because it's their copyright. If you don't pay the band, then you'll have a copyright infringement case against you. People on YouTube, if any of you have ever published anything with someone else's work in it, you may get a copyright strike from YouTube. That's what this is about. Some people try to avoid that and they use music that has been in the public domain. So if you use classical music from Mozart, he's been dead for a couple of hundred years at least, so he's not going to have a complaint about it. The trick is, though, if you have a recording of Mozart's music, but that was recorded fairly recently, the people who produced that, they may need to get a copyright payment. So if you can just get a keyboard and you play a tune that was written by somebody that's not copyrighted anymore, you can feel free to use that in your production and you will not have to worry about copyright lawsuits. A trademark is also governed by the USTPO, and that is a word, phrase, symbol, or design that identifies or distinguishes some type of goods or services that a party is using from others. And I think I made the example of the golden arches from McDonald's or the script Coca-Cola, that they've spent millions, probably billions of dollars over the last century making that their symbol. And if anybody tries to use that as a symbol and it confuses customers so that they don't know if they're buying Coca-Cola or some other product, it can even be a product that looks similar. It could be Coca-Cola, and if it had the same script language or same design, people might confuse that product. So the whole idea of trademark is that you create a trademark, it identifies your product so that people can use a quick shorthand and know, oh, this is what I want to buy. It can be registered with a mark application. The key question is whether or not somebody else is using something very similar that creates confusion in the consuming public's mind. Because if I spent a lot of money creating my trademark and somebody else is using something that's either the same thing or very similar, and people are buying that product instead of mine by mistake, then there's a lawsuit waiting to happen. Warranties are promises that the goods or services that you sell will meet the standards of performance. This is basically a contractual obligation because when you buy something, it's a contract, which we'll talk about in a couple more slides. If I buy, again, a lawnmower and I take it home and that lawnmower doesn't work, then there's a violation of the contract. I paid money to get something that is supposed to do something. I have a warranty on it. Even if they don't tell me I have a warranty on it, there could be implied warranties as well. So it can be a written warranty. Typically, the written warranties are the ones that limit them in time. If you buy a car, it's usually 6 years, 60,000 miles, and it's very specific about what they cover. It could be 3 years, it could be 10 years, depending on the type of warranty that you're getting. So the types of warranties are express, which means they come right out and tell you that there's a warranty, or it could be implied, which means the company doesn't have to say anything, but there's still a warranty because it exists based on the nature of the product and the service that's being sold. Now, one of the laws that covers the warranties is something known as the Uniform Commercial Code, or UCC. This has been adopted by the state of Massachusetts, so the number here, 2313, is the same. It's just a Massachusetts general law, and that it would be the same section. You can have an express warranty by an affirmation of a fact or promise. Hey, buy this lawnmower, it's good for a year. Warranty, parts, and service. You can have a description of the goods, meaning that this is guaranteed to work. It could be a sample or a model that you show that this thing is supposed to work to provide you with the value that you're giving up your money for. You look at the seller's words or actions, and that becomes the basis of the bargain. If I'm told that I'm buying this lawnmower and it's going to be good for 3 years, then that's why I'm buying this lawnmower. I could have bought another lawnmower that didn't promise it to me. And if they violate that warranty, it's violating the bargain. I'm not getting what I paid for. You don't have to use the words guarantee or warranty to get an express warranty. The overall behavior and all the things that were said, if it suggests that there's a warranty, then that's going to be good enough. An implied warranty is created by the Uniform Commercial Code, and it doesn't matter if the manufacturer or seller is actually trying to give a warranty. They may not even have an express warranty. And even if I tell you I don't have any warranty at all, there's still going to be some requirements. There's some restrictions on it. There's a warranty of merchantability. This means that if you buy a particular product, it should be fit for the purpose that it was sold for. If I'm buying a lawnmower, it should be able to cut my grass. If I buy a product and it doesn't do anything, then it's a violation of the warranty of merchantability. And it doesn't matter if they didn't tell me that there's an express warranty. This is something that exists at law. The statute that was passed puts this burden on those who are selling products. The warranty of fitness means this could be excluded or modified by the language if you went to an express warranty, but we're talking about implied warranties here. The seller should have knowledge that the particular good or service is being created to be fit for that purpose. And if it doesn't fit that purpose, there's an implied warranty. And if you buy something that doesn't work, you can take it back to the store and they should be able to replace it or fix it. Contracts is a real core of what most businesses are based on. A contract is basically an agreement between two parties that is legally enforceable. So if I have an agreement with one company buying goods from another company, you expect that those goods will be delivered. In return, you expect those goods to be paid for. If those goods are not delivered or those goods are not paid for, then the party that is affected by that could have a case in court. Now, what makes a contract and not just a regular promise or agreement is what we call the elements of a contract. The main thing, and I'm going to go out of order here, but the main thing that differentiates a regular legally enforceable contract from a promise is what's known as consideration. Consideration is the exchange of value. It doesn't have to be money. It could be something else of value. I could exchange like in bartering. I could give you one thing for something else, or I could do a service in exchange for something else. But it has to be something of value. And it's called bargain for consideration. I'm going to sell you my car. I offer $10,000, you come back at 5, maybe we agree at 8. The $8,000 is the consideration, and that's what makes the promise for me to give you the car and your promise to pay me the car legally enforceable. So that means I can go to court and have an order making one party either sell the car or the other party pay for it. If you don't have consideration, you do not have a contract. If you invite me to your party and I say, sure, and then I don't show up, can you sue me? No, because it's not a contract. It's just a promise. I'm not in breach of a contract. I may just be kind of a jerk. But if you ask me to go to the party to be the DJ for the party and you're going to pay me $300 to do it, and then I don't show up, now I'm breaking the contract because there's valuable consideration here. If I don't go and you're paying me to be there, then that's a contract breach. In order to even get there, though, you need to have an offer, which is me saying, hey, would you like to do this? And you accepting that offer. If you only have an offer and someone doesn't accept, there's no contract. If I have an offer and then I revoke it, and then you change your mind and decide to accept it after it's been revoked, you can't accept an offer that isn't there. If, for example, I send you a communication and it says, if I don't hear from you, I'm going to assume that you want to purchase this product, and then I send you the product and say you have to pay me for it. That's not a contract because I can't force you by silence to accept an offer. I have to say, hey, would you like to buy this? And you have to say, yes, I would. You need to have both an offer and an acceptance. It has to be done according to the terms of the offer. So if it's in writing and I require it to be in writing, it must be in writing. You can have oral contracts too. I'm not going to get into the details. There's a whole thing called the statute of frauds about when it needs to be in writing. Just know that oral contracts sometimes are okay. If you have any questions, though, reduce it to writing. And it's always a lot easier to go to court to prove your case if you have something in writing with another person's signature on it that indicates the terms of the agreement and that it was accepted. You also have to have the legal capacity to enter into a contract. You have to be the age of majority. If you are a minor, that means you're under 18 years old. Even if you accept an offer, a validly made offer for consideration, and you agree to it, but you're 17, you can disaffirm that contract. You can break it, and you can do it without legal consequence. So if you're in business and you're doing a contract with somebody, if you're selling a car or selling something else, if it's somebody who's 17 years old, you get a parent or guardian to co-sign that agreement, or that contract may not be enforceable against the party, because if you're a minor, you can back your way out of a contract because you are not considered to be mature enough to decide whether you should enter into a contract. You can also have limited capacity because of mental illness or some other type of disability. You could have Alzheimer's if you're older and not be able to understand the nature of what you're doing, or you could be under the influence of drugs or alcohol. You have to have real good proof, though, that you were so drunk that you could not appreciate the consequences of your actions. You could also be under duress. If somebody puts a gun to my head and says, buy this, and I say, okay, that's not a legal acceptance because it was under duress. I didn't really want to enter the contract. I felt I had no choice. The whole point of a contract is that people freely enter into it. If I want to be bound by a contract, it should be my choice, not because I'm forced to do so. Contracts also have to be legal. So if I offer to sell you a kilo of heroin and you say, sure, that's great, and then you don't pay me, I can't take you to court and ask for my money because the court will know that I'm a drug dealer. And since it's not a legal activity, it's not a contract. A breach of contract is simply a failure without any legal excuse. If you break a contract without any good reason for it, then you are liable for any damages that ensue. I could have partial performance that would be considered a breach because I didn't do everything that I promised. It could be a problem with the product, either because of an express or an implied warranty. That all goes into contract. If I didn't give you a product that you had agreed to buy because it's defective or something, that's still a breach of contract. So even though we're talking about warranty issues on the previous slides, it really comes down to failing to fulfill the terms of the contract. When a breach is material, meaning that it's something related to the actual purchase, the non-breaching party is released from performing. So if I'm going to sell you my car and you don't pay me, then I don't have to sell you the car. If you're supposed to pay me a down payment by a particular period, then I'm discharged. So I don't have to worry about being liable for breach of contract because you breached something material, which relieves me of my requirement to fulfill the contract term. If the breach is not material, then it will not be a breach of contract. Something material means that it's related to the real terms of it. So you could have a contract that says time is of the essence. If I say, I want you to deliver these products to my store by Friday at noon, time is of the essence, that's telling you if you're not there by Friday at noon, then you're going to be in breach of contract because I have a requirement from other customers that I need to move those products out for, and I'm going to lose money as a result. If time is not of the essence and you deliver it at 2 o'clock, it's a breach, but it's going to be a non-material or an immaterial breach. there really isn't any damages that come from it. And therefore, even though it's technically a breach, I ended up getting what I needed. It was just a little bit of a delay. So it's not going to be kind of a big problem. In basketball, they call it no harm, no foul. So let's say you have an offer and acceptance, then you have consideration. Parties all have legal capacity and it's for a legal thing. It's not something that's outlawed by any statute or anything. If there is a breach of a contract, then a remedy is how to fix it. And you can go to court to try to get compensated for damages. The damages are the expectation damages. This is very similar to compensatory damages that we talked about in torts. You're trying to put people in the same position they would have been had the contract been executed correctly. Reliance is that I relied on you to go ahead and send me these products that you told me that you're going to deliver. Time is of the essence at noon. Now I'm going to lose $10,000 worth of business because you breached. So because I relied on that, you could be liable for the other damages that I have as a result, as a consequence of your breach. If I can't prove expectation or reliance damages, then the last thing is restitution, which is basically to let me out of the contract. Specific performance comes up when you're talking about something that's relatively unique. This is very rare. I don't want to say it's very rare, but it's not that common in the regular business structure. If you have monetary damages that are insufficient, you can order specific performance. If I'm buying a product that is like a rare painting, there's a one of a kind, it's the only one, and I gave you the money and you've breached the contract, I can't go out and buy another one. There's no other substitution for it. So I can ask the court to force you to sell me that product. Specific performance always applies to houses. If you're trying to buy a house and someone breaches the contract, you can't find another house that's going to match that because every house is unique. So I could ask the court to order specific performance. They would require the defendant to sell that house to me. Now, specific performance, when we're talking about services, it's usually not applicable because if you don't want to work for someone and then you breach a contract, having the court order you to work for someone is almost akin to slavery. It takes away free will, and it's also incredibly difficult to monitor. If you don't like someone, if you are in a situation that you don't want and the court orders you to do something for this other person anyway, it's probably not going to work out very well. So specific performance is only about things. It's not about performance of services typically. There's a lot of laws that protect consumers. People buy products, they ingest food, they use other things that could be potentially dangerous. We want to make sure that people are going to be protected. So there's a lot of things that have been put forth by both the state and federal governments to help people stay safe. The consumer protection legislation includes things like product safety, consumer credit, and automobiles. The Consumer Product Safety Act, or the CPSA, creates the Consumer Product Safety Commission. So that's a administrative agency that goes in and looks into enforcing various standards. And they can also ban products. The Food and Drug Administration, or the FDA, they look into food, drugs, cosmetics, biologics, medical products, and tobacco. If there is food out there that's been tainted by salmonella, they can go out and say, you have to stop selling that. The FDA can actually discover a problem and then order a change to it. If you're selling a drug that now has side effects that are too dangerous to be acceptable, we can ban that drug from being sold any further. The Fair Credit Reporting Act, or the FCRA, deals with credit reports. So you have a FICO score, a credit score. You can go to one of the places to find out what it is. If you're over 750 or 800, you have very good credit. If you're in the 500 range, you have not so good credit. If you do a Fair Credit Reporting Act case, that means that somebody maybe is hitting your credit report and it's affecting your ability to be able to buy things. If you have bad credit, you typically have to pay more interest. If a bank is going to loan money to someone, they're going to give the best interest rates to the people that are going to probably pay them back. If you are a risk not to pay me back, I need to be safer, so I'm going to charge you more money for that loan. So if somebody did something wrong to affect your credit rating, you should have some type of recourse to be able to review your credit and make any corrections. So that is something that was established by the federal government. And if you have a complaint against one of the companies, the Experians of the world, you can file a report with them and say, I think this is inappropriately bringing down my credit score, please correct it. The National Highway Traffic Safety Administration, or NHTSA, the NHTSA, they look at vehicle safety and they also have the ability to do recalls. If there's a car out there Back in the 70s, if it was the Pinto, they could have said, hey, you need to recall this and fix it. You need to stop selling it, or they could force you to correct the problem as well. Ordinarily, the government doesn't like to get into the way businesses do their thing, but if you're doing something that's causing a significant threat to the health, safety, and welfare of people, the government feels that it's appropriate to step in and make sure that these products are not going to be harming people. There's also antitrust legislation. It could be that a trust is a group of companies that work together in collusion. They have a secret handshake agreement to control prices and supply production, to be able to dictate what the prices should be instead of relying on competition. We mentioned before, competition helps consumers. When you have a lot of people making a product, they're all going to be trying to make the best, cheapest product at the highest quality so that you will be able to go out and pick the one that suits your needs. If there's only one company making that, then that's the only place you can buy it from, and you will pay whatever they tell you to pay, whether it's good or not. So antitrust legislation is designed to prevent monopolies from taking place or developing. We want to have a competitive market that gives good prices, good qualities, and good choice to consumers. We also want to have there be innovation. We don't want one company to simply own one particular part of the market and then just sit on it. You'll never get any new innovation as a result. If somebody has a great product, you can start to compete with them and make a better product or make a slightly different product. If it's a monopoly, then that's really not going to happen. The three main laws that we're looking at are the Sherman Antitrust Act, the Federal Trade Commission Act, and the Clayton Act. The Sherman Antitrust Act came out in 1890 after Congress recognized that there were too many monopolies that were affecting the economy and making it very difficult for people to compete. It basically gives the government the ability to dissolve trusts, to break up these companies that are acting in collusion, or to target a large company that has essentially a monopoly stakehold in a particular field or industry and make there be some competition. Right after it was passed in 1890, the Supreme Court said that the extent of the law is limited to only unreasonable restraints of trade. Again, what is reasonable is kind of a term of art, so you have to look at former case precedent to determine whether or not what a company is doing is considered to be a monopoly in violation of the Antitrust Act. The Federal Trade Commission Act is a consumer protection statute, and it created the Federal Trade Commission, or the FTC. They regulate a really broad swath of the economy in terms of business transactions with consumers. They can look into unfair methods of competition, unfair or deceptive acts or practices. If I'm selling a product and I'm claiming that it does things that it doesn't do, I could get hit by the Federal Trade Commission. They could make me stop doing it. They could fine me. They could make me stop selling it entirely. They could also fine people and provide for rebates or paybacks to consumers that have been damaged from products that were not safe. They can also make rules that define what types of practices and acts are fair. They will pass regulations under the Federal Trade Commission. So the Constitution created Congress. Congress created the Federal Trade Commission Act. The Federal Trade Commission is the administrative agency overseeing the law, and they can pass regulations that really go into deeper detail. And if you happen to be in a field where you are regulated by that, you will have to comply with those rules. The FTC will also compile information and look into investigations for companies that are doing things that are considered to be a violation of the Act. The Clayton Act came out in 1914. It was a way to strengthen the Sherman Antitrust Act. The Clayton Act bans price discrimination, anti-competitive mergers and acquisitions. So if one company buys up too much of the competition and creates a monopoly type situation, the Clayton Act can be used to break it up or to prevent the merger. And it also allows strikes. People who are working for a company have the right to go out on strike. It allows boycotts, and it allows labor unions to take place to help not necessarily strengthen the consumers, but to help out the employees as well. That's going to be it for this chapter. Next week, we'll do the forms of business, and that'll be chapter 7.